Well, good morning, everybody. Welcome to our new event of the IBRADEMP. This is a delight for us to host. We have here an international event where we have very important people from Hastings, alongside with myself and also with Machado. What we're going to be talking about today is the Chapter 11 and all its different characteristics and interesting features, especially for Brazilian companies who wish to file for this type of procedure in the US. It's very common for us to see, our RJs here, our judicial organization, our recuperação judicial here in Brazil, adopted by most of the Brazilian companies. But we've seen in the last few months some precedents, very interesting ones, where Brazilian companies have chosen to file directly in the US a Chapter 11, which has obviously very interesting implications, not only there, but also over here. So this is basically what our panel is going to be discussing in this next hour. And we're very happy for everybody who's been able to join us. Let me introduce our team. As you can see on the screen, we have here Pedro Jimenez, who is a partner at Hastings, based in New York. We also have Jonathan Kellner, also a partner at Hastings, but based here also in São Paulo. We have also Andrés Mena, a partner at Hastings, also based in New York. And we have Machado, partner at TozziniFreire, based here in São Paulo. So with those and I myself am Herbert Kugler, partner of TWK Advogados here in São Paulo. So with that, I think we can get right into it. I would invite either John or Pedro to give us a brief overview of what exactly is the US Chapter 11. And to say already, it's a pleasure to have you guys with us.
Pedro, after you.
Thanks, John, and Herbert, thank you for the introduction. What I want to have us accomplish today, I suspect many of you participating today are familiar with Chapter 15 of the US Bankruptcy Code. There were a number of Brazilian companies when they went through a round of restructuring in Brazil that utilized Chapter 15 to help them reorganize their business and obtain the benefit of a stay of actions against them and against their assets in the US. And the Chapter 15 case, by its nature, is very limited. It's really intended to assist and complement a proceeding in the company's home country. Chapter 11, by contrast, is intended, as Herbert mentioned, intended to be equivalent of the recuperação judicial in Brazil. It really intended to be a very robust and comprehensive law to assist a company in the ability to reorganize its finances. It is not uncommon to see foreign companies decide to utilize Chapter 11. As I'll discuss in a few minutes, it is very easy for a foreign company to be eligible to commence a Chapter 11 case. But let me just quickly lay out some reasons why a company would utilize Chapter 11. There are typically two types of restructurings that can be accomplished through a Chapter 11. We have what's called a right side restructuring. Typically, that is a problem with the debtor's capital structure, too many liabilities, maturities on their liabilities coming up, and the companies need to utilize Chapter 11 to help them address and restructure those liabilities. And we have what's called a left side restructuring, where the problem there is not so much with the debtor's capital structure, but with its operations. Labor costs are too high, and the company needs the benefit or use of Chapter 11 to help them rationalize their labor costs. Problems with burdensome contracts, whether it be customers or suppliers, where the contracts are no longer beneficial and really cumbersome on the business. And the debtor needs to utilize Chapter 11 in order to help restructure or potentially get rid of those burdensome contracts. In my experience, and I've been doing this for a long time, when foreign companies have attempted to utilize Chapter 11, it really has been limited to the right side restructuring. They have US law governed bank debt or US law governed bond debt, sometimes both. The company needs to attempt to reach a restructuring of that debt, and they'll utilize Chapter 11 because typically the lenders, the bondholders, they have contacts with the US, the debt is governed by US law, and therefore use of Chapter 11 has been very beneficial to these foreign companies that have wanted to utilize a proceeding to help them restructure that debt. I will point or will note that the recent trend not only has been for the foreign company to utilize Chapter 11 to attempt to achieve a right side restructuring, a restructure of their capital structure, but now we have companies that have a lot of operational issues that they're trying to restructure through Chapter 11. If you look at the recent examples of Avianca and LATAM Airlines, I know LATAM Airlines is near and dear to many of you since now the Brazilian entities have become part of the Chapter 11. There, yes, both airlines have a number of capital structure issues they're trying to work through. So a lot of them have significant amount of debt, especially compared to limited revenue they're able to generate right now, while the airline, at least the passenger side of the airline, has been on hold. But they also have a number of operational issues. Many of them now have determined that they have more aircraft than they need. And they've utilized Chapter 11 to address a rationalization of their aircraft fleet and how to minimize the costs associated with their aircraft fleet. So it will be interesting to see whether these new Chapter 11 cases that we're seeing of the airlines will work from the standpoint of utilizing Chapter 11 when many of the operational issues, if you really peel back a layer of the onion and look at them, tend to be a home country operational issue. One example that's easy to talk about is I think both Avianca and LATAM are likely to want to rationalize their labor force as they figure out what the airline looks like coming out of Chapter 11. They're likely to determine we don't need to have the number of employees that we have now. We need to figure out a way to rationalize that labor force and make it consistent with what our new business plan looks like. And there's going to be a contrast there of, can you use Chapter 11 to help restructure labor obligations that exist in Chile or Colombia or Brazil? I think that those are going to be more challenging issues that these companies are going to have to work through. But at least for now, Chapter 11 is proved to be very helpful to these airlines while they're in this pattern of wait and see when they can resume passenger operations. I mentioned earlier eligibility to file for Chapter 11. Case law here is very consistent. Any company that has assets in the United States is eligible to file for Chapter 11. The case law interpreting what constitutes assets has been as US Chapter 11 friendly as you can possibly imagine. The courts have held that any assets whatsoever, even the presence of a bank account. Some courts have gone on to hold that even contract rights under a US credit agreement or US bond indenture are sufficient to confer eligibility to file Chapter 11. So from the standpoint of when you're talking to a company who's thinking about Chapter 11 and they ask, well, can I? The answer is going to be absolutely yes. But I think the bigger question, and we'll talk about it in a few minutes, is what practical limitations do I have in utilizing Chapter 11 if really all of my operations and the issues that I'm trying to deal with are based outside of the US? There are three types, to make sure everybody's clear. There's three types of companies or industries that are not eligible to utilize Chapter 11. You have first banks, you have insurance companies, and you have brokerage firms. If you think about back in 2008, when Lehman Brothers filed for Chapter 11, there were aspects of the Lehman business enterprise that were not eligible to file for Chapter 11 because they were governed by other regulatory schemes of US law, and therefore those entities utilize what's called a SIPA proceeding or other types of proceedings to attempt to wind down those businesses. But the main Lehman business that was not the brokerage business was eligible to file and did file for Chapter 11. Liv, do you want to kind of just contrast that a little bit with Brazilian law and how you view RJ as what types of companies can file and cannot file?
Yeah, just to make a comparison between Brazilian, the Chapter 11 and Brazilian legislation, we have different requirements for the filing. So it's not enough in accordance with Brazilian law only to have assets here. So the company needs to be actually based in Brazil in order to file a judicial reorganization case. So I think this is the main difference at this point. And I think that you will also comment on the possibility of the creditors filing the Chapter 11 also, but that doesn't occur here in Brazil. Only the debtor is entitled to file for a judicial reorganization case. So I think this is also an important difference, but please go ahead, Pedro. I think we have other.
Thanks, Liv. So once the company's filed for Chapter 11, I think very much like in an RJ proceeding, maybe with some small differences, it is the company's board of directors and management that continue to operate the business while the company's in Chapter 11. The rationale behind that is, believe it or not, even though these are the people that got you into Chapter 11, they're also the ones that are best suited to get you out of Chapter 11. So absent evidence of fraud or dishonesty on the part of management, they are going to stay in place. They are going to be the ones to help attempt to come up with a business plan and a reorganization plan that will help the company get out of Chapter 11. As far as other critical or key players in a Chapter 11 case, we have a concept of an official committee of unsecured creditors. That is a committee that is normally composed of the 7 largest creditors, and it is ultimately selected and appointed by an arm of the U.S. Department of Justice called the U.S. Trustee Program. They normally solicit the top creditors as listed by the debtor, and with the idea of trying to come up with a good mix of different types of creditors. If you look at, and I'll pick on Avianca and LATAM again, if you look at the committees that were appointed in those cases, there was a relatively good cross-section. You had some bond debt, you had some labor debt, you had some vendor debt, some customer debt. So from that standpoint, they tried to come up with a good mix of different types of unsecured obligations that the company has in terms of how to best constitute that committee. That committee has a significant amount of say in the bankruptcy case. The judge will always look at the committee to try and solicit the committee's views on a particular issue or particular matter that the company is attempting to do in the Chapter 11 case. So it has a significant amount of power. It has a seat at the table in terms of trying to negotiate recoveries for unsecured creditors in the bankruptcy case. Some other very important players in the Chapter 11 case, and I think now you're seeing them more and more. For those of you that followed the LATAM debtor in possession financing fight, one of the critical players there was an ad hoc committee of bondholders of LATAM. These are both US-based and foreign-based holders of LATAM bond debt who organized together for the purposes of trying to ensure that LATAM did things in a way consistent with trying to maximize recoveries to unsecured creditors. But in this case, they actually went one step further. The ad hoc group, at least some of them, were interested in providing financing to LATAM Airlines. They believed that the proposal that LATAM Airlines presented to the court was not superior to what this group was prepared to provide, and they went out and put on a fairly lengthy objection to approval of LATAM's DIP financing, and actually that entire fight is continuing later today. So we'll see where the judge comes out on approval of the DIP financing versus other alternatives that have been presented, including an alternative by this ad hoc committee. But a significant, and ad hoc committees for that matter can have a significant play and seat at the table in the context of a big Chapter 11 case. The other big player, and obviously can't forget, is the Bankruptcy Court. U.S. bankruptcy courts are made up of judges. Many of them have been bankruptcy practitioners for a very long time, have significant amount of understanding and wherewithal when it comes to adjudicating very complex bankruptcy issues. And maybe unlike some other jurisdictions, that's all these judges do. They're not bankruptcy judges by night. No, they are bankruptcy judges 24/7. All they see are bankruptcy cases. Depending on which jurisdiction we're talking about, some will see more individual bankruptcy cases than others. But when you talk about the main jurisdictions where you see these foreign debtors file for Chapter 11, New York, Delaware, I think now to a lesser extent, Texas, the judges there are extremely familiar with all of these complex issues. And in fact, many of them have authored opinions on how to deal with these complex issues to give companies that are looking at potentially filing for Chapter 11 some certainty as to how these issues are likely to play out.
Pedro, if I could just intervene.
Yes, Herbert.
One of the main questions that I think we have is that what exactly can I subject, what type of debts, what type of claims can I subject to the Chapter 11? So you mentioned, for example, can I subject labor issues that I have in Brazil to a Chapter 11 abroad? Okay. So if you could just give us a little color exactly on what I can put into a Chapter 11 abroad.
Sure. Sure. So Herbert, so the starting point is every claim that the debtor has can be restructured through Chapter 11, whether it be a labor, whether it be a contract claim, whether it be a financial claim. So from the standpoint of, are there claims that I cannot restructure through Chapter 11? The answer is no. You can restructure all of them. The issue that I think is going to come up for a lot of these foreign debtors is, so now what happens if the creditor whose claim I've restructured disagrees with me? They don't believe that you can use US Chapter 11 to restructure my claim. I'm a local creditor based in Brazil. I have no assets in the United States. I have no contacts with the United States. Good luck. You restructured my claim, but I'm going to file suit against you in Brazil to collect on my claim, and there's nothing you can do about it. That I think is where the rub is going to come up, Herbert, on how these claims are going to ultimately be addressed. If you look at, and again, I'll pick on Avianca Latam for a second. If you look at what Avianca Latam did very early in their Chapter 11 case, they anticipated that this issue was going to come up. So what they did is they sought relief from the U.S. Bankruptcy Court to be able to pay claims of foreign creditors where they believed that foreign creditor was not going to respect the Chapter 11 process. And they have a significant amount of money now authorized to deal with those claims as they come up. I think the bigger, better question you asked is, okay, so now I've dealt with an individual vendor who has a $10,000 claim against me, who's not going to respect the Chapter 11. I've paid them off. Great, I've dealt with that creditor, but I need to restructure my labor obligations. I've got millions and millions of dollars committed to deal with labor claims, but my labor unions, for instance, outside of the US are unlikely to respect Chapter 11. They're not subject to Chapter 11. How am I going to deal with that? I think there are going to be some limitations on the debtor's part in being able to use Chapter 11. And I think they're going to have to work consensually and constructively with their labor unions if they want to try and restructure those obligations. So I think there may be more of a challenge in how effective Chapter 11 will be to address those types of obligations.
Yeah, for sure. Liv, can you give a little color on how you think that, I mean, in Brazil, a restructuring of a Chapter 11 abroad would be received, especially by our courts? I mean, if I had a court order abroad, restructuring said class of creditors, how would this play out probably in Brazil?
Yeah. Well, Brazil does not adopt the Unsecured model law. So there's no option like it happens in the US for the debtor to file a restructuring proceeding abroad and then get it recognized in our jurisdiction. So in this case, in order to have effects in Brazil, for instance, for example, Latam would have to file a judicial organization in Brazil to have like for us effects like the stay period, because under the Chapter 11, the debtor is also entitled to a stay period, but of 120 days, right? But so it doesn't have effects, at least until another proceeding is filed in Brazil. And what the debtor could do or should do is to have the proceeding decisions of the proceeding abroad recognized by the Superior Court of Justice here in Brazil. We have a precedent of our Superior Court of Justice from a case of the BVI. It was a liquidator seeking to recognize, to get a decision from the court in BVI recognized, because this company in BVI was a shareholder of a Brazilian company that was also under judicial organization in Brazil. But the Superior Court of Justice found that it could jeopardize the rights of the creditors in Brazil and granting a benefit to the foreign creditors in BVI. So that's the precedent that we have until now that can give us a sense of how would the Superior Court of Justice would behave in case of recognition of, if it needs to recognize a decision that was rendered in the United States, for example.
I see. And I think given that, troublesome recognition procedure, let's say, for example, that a creditor here simply decides to disrespect the Chapter 11 restructuring and files for suit here in Brazil. Would he get a slap on the wrist from the U.S. court? Is there anything that the company can, pursue in the U.S. to try to contain it, or would it have to adopt something local besides?
Do you mind if I take this one? This is like my favorite question. Pedro and I have talked about this issue for like 90 days in a row, like every single day. The answer is that it depends. If you have a creditor violating the stay who is literally completely local and has no exposure whatsoever to the United States because he doesn't have assets there, he or she has never traveled there, he doesn't care about ever visiting the United States, then maybe there's not a lot you can do. But more material creditors rarely fit the bill. They usually have something in the United States, and they're as a result exposed to US jurisdiction. And if you are exposed to US jurisdiction, you just don't want to do this. Number one, because you'll get sanctioned, and those sanctions in the United States, as we all know, are very real, as in, think thousands of dollars a day. But second, because a bankruptcy court is likely not going to look very favorably of someone who shows up at the Chapter 11, first violating the stay and then asking for relief. Remember that part of your relief is to participate in the distribution of whatever the Chapter 11 ends up paying. So if someone thinks about violating the stay solely based on the fact that he or she is Brazilian, that should be giving a lot of analysis, because it is a very risky move, and one that I think generally would not be advisable to anybody who is not 150%, domestic.
Yeah, excellent. And I think, Pedro touched upon the LATAM case quite a few times, and I think one thing that impressed, at least, especially us Brazilian lawyers, and I think our system, was the speed with which they were able to obtain a DIP finance. Okay? The speed with which you were able to, accomplish very complex things in the U.S. court system. So, Andrés, John, if you could touch upon a little bit, how is it feasible for you to get that complex a finance, say, in that short of a time? Because I think that when Brazilian companies analyze and view the pros and cons of which system they prefer, speed is essential in any company in restructuring, but I think the American response has been amazing.
Because the American process relies on the parties doing their homework, essentially, right? Because we have an adversarial system, even in bankruptcy court, right, represented by the debtor and at least the UCC. You get to parties who kind of know what to look for, and they can react relatively quickly. If you have the benefit of time to prepare for a bankruptcy, and remember, oftentimes you get, 45 days, a year. I've been involved in, planned bankruptcies that started being prepared 18 months before they actually filed. Because you have some amount of time and there's a market that has developed around what a dip looks like, you can sort of work in it like you would work on any other securities issuance or on any other credit agreement. And if you have, again, the benefit of time, you will show up on your first day in court with a beautiful, term sheet summarizing the 200-page long document, and a document that people will sort of fairly quickly recognize what it does, including the judge, very critically, right? But more importantly, the adversarial parties, the people that can complain about it, right? You, of course, in a Chapter 11 don't often have the benefit of time. And oftentimes you have literally a week, right? Because you cannot make payroll next Friday. And what you do in those cases, and I think Pedro and I have both done this, is you agree on a dip that instead of being 200 pages is going to look like a promissory note, like a pagaré, right? And it's going to have, 7, 8 pages. And it's going to be maybe for a shorter period of time. It will need to be renegotiated once you file, but it allows you to get over that hump. And because lenders, especially because you're more likely dip lenders are your existing lenders, because those guys want you to, in fact, have an orderly process. No one benefits from you basically jumping over a cliff. They will probably support you on that. And, you get the 200-page long document or the 7-page long promissory note. It depends on the background.
Yeah, I would just to add to that, and Andrés is 100% right. I think LATAM and Avianca are actually outliers in the sense of how normally you see dip financing get done. Typically, for a traditional U.S. company that's filing for Chapter 11, its cash has already been pledged to its lenders. And therefore, once it files for Chapter 11, it can't use that cash without the lender's consent. Or as Andrés mentioned, they're literally about to run out of money and are going to have to shut their doors within a week, sometimes even less time than that, unless they obtain additional financing. So when the company files for Chapter 11, typically on the very first day of the case, the court's approving financing at least on an interim basis so that the company can get access to some cash so that it can continue operating while the Chapter 11 is going and the committee is formed and has an opportunity to review the terms of the dip financing and the like. If you look at Avianca and LATAM, they filed without a commitment for all of their dip financing. They had some commitments, but not all of them. And they were able to do that for, I think, 2 reasons. Number one, their operations had been suspended for the most part. And therefore that huge cash burn wasn't necessary. And I think importantly too, that their lenders didn't have liens on their cash. So they didn't have to go out immediately and get lender consent to use their cash or have to go out and get financing immediately. If not, they were going to have to stop operating. They in fact had already stopped operating. So they've been able to utilize the Chapter 11 process to do a marketing of parties that may be interested in providing the dip financing and do things a little bit differently than what Andrés and I are used to seeing, where typically, again, when the typical U.S. debtor files for Chapter 11, they already have their dip financing already committed to, in most cases. Andrés, you want to talk a little bit more about the dip and kind of things that we see?
The LATAM dip is actually fascinating because, as Pedro was describing, it has not worked out in the way one would have expected it necessarily to work out. That's not a bad thing per se. It's just, I guess, the nature of the circumstances. But what's been fascinating is to see live in such a public case and in such a big case, LATAM being basically forced to market a little bit the dip, right? Because the opposition it's finding has forced it basically to already change the terms of the original financing it was proposing. So this unusual feature of the convertibility, it's not technically convertibility, but of the loans being convertible into shares of a new entity or of the succeeding entity, whatever this ends up being, that fairly unusual structure has become less favorable to the dip lender / shareholders than it was in the beginning of the case, because opposition has actually shown, this is kind of an unusual set of economics. Same with the interest rate. Interest rate has gone down. I mean, there's a bunch of little things here and there in these dips that have actually gotten better vis-a-vis the borrower in the estate, and that has been solely the result of almost a forced marketing. That is a very interesting feature, not one you see often.
I'm happy that the Brazilian companies, even in the U.S. system, have innovated and giving some level of excitement to the DIP finance abroad.
Liv, how would the DIP financing work in a Brazil restructuring?
In Brazil, the super priority of a deep finance is not that clear in our law, because we have in a liquidation case, if it turns out in the future to be a liquidation case, restructuring. For example, there are other costs and expenses that will have priority on a deep lender. For example, the fees of the judicial administrator. So it's not that clear in our law, and I think we don't have that culture in Brazil to lend money to distressed companies and companies under distressed situations. So I think this is probably one of the reasons that Latam filed and chose to file the Chapter 11 in the US instead of Brazil. And the other issue is that, like Herbert commented, usually you have to provide the deep finance in a plan because most of the time the judges, the courts are not comfortable with granting the authorization of a deep finance without having the creditors on board. So it takes time to get a plan negotiated. And so that's, for this reason, most of the times we have to extend the stay period because we don't have enough time for creditors and debtors to negotiate a deep finance. And probably the lender will have to get new guarantees. And in order to have new guarantees, the court and the creditors must approve and authorize previously these new guarantees. So it's a proceeding that it's not that expedite that fast like in the US. So
yeah. Now, I mean, going into a little bit regarding the plan to approved in a U.S. setting, exactly how does that approval happen? I mean, here in Brazil, we basically need the plan to be approved by the majority of 4 classes, which are divided in labor, secured, unsecured, and small businesses. In the U.S., how does this play out? Are creditors divided by classes? Do they have, I mean, all of them have to approve? Is there something like a cram down? I mean, how would a Brazilian company approve this abroad?
Right. So in the US, the debtor, I think one thing worth mentioning, they have the exclusive right to present the plan during at least the first 4 months of the Chapter 11 case. That time period is very routinely extended. And normally the debtor can have up to 2 years, where it is the only party that can present a plan of reorganization. No creditor can present a competing plan. As far as what you would normally see as far as contents of a plan, Herbert, the debtor has a lot of flexibility on how it can classify certain claims, although you can put them in the buckets of secured and unsecured. Within secured and unsecured, the debtor has the ability to create subclasses, of secured claims and unsecured claims. So for instance, it's not uncommon on the secured claim side for the debtor to break out classes depending on what collateral secures that claim. So if you have bank debt that is secured by your receivables and your cash, you normally see that secured claim as, secured class, subclass 1. And then if you have bond debt that's secured by other assets or other secured claims that are secured by other assets, they would be separately classified in secured class, subclass 2 or subclass 3, depending on how many different types of secured claims may exist against the company. And very similarly for unsecured claims, they don't need to all be lumped together. You can have different reasons why you want to break out your unsecured claims into different classes, and debtors normally do that. They do have to have a rational explanation why they're separating them, but the case law has been pretty consistent in giving the debtor a lot of flexibility, and virtually any reason for separating them will be accepted by the court. And then the second thing, you have to treat these unsecured classes similar, not exactly the same, but similar. The test is you can't unfairly discriminate one class of creditors against another class. And notice, it's not discriminating, it's unfairly discriminating. So there is some discrimination allowed, but the courts want to say, okay, look, you can't give one unsecured class 0 and give another one a full recovery. I know that's an obscene example, but the idea there is they have to be treated similar. And the debtor, again, they get a significant amount of flexibility in how to structure the plan. You may want to create a convenient class of unsecured claims that could be your accepting class, and oftentimes debtors take advantage of that. You don't have or need to have every single class accept the plan. You can take advantage of one accepting class. The way you measure acceptance, and you know, Liv, I welcome kind of the contrast with the RJ process in Brazil, is you look at that class only in terms of creditors that actually vote, not the total amount of debt in that class or the total number of creditors in that class. And based on creditors that actually vote, you need 2/3 in amount and more than 1/2 in number to accept the plan. If you get more than 2/3 in amount and more than 1/2 in number, that class is deemed to accept the plan. And you can use that accepting class to cram down the plan on every other class under the plan. For a cram down, the case law looks at whether the classes or the claims are secured. If the claims are secured, you can cram down that class. If you either one, give them the economic bargain that they structured, which is typically you either sell their collateral and give them the proceeds, or just hand them the keys over and say, here's your collateral, take it back. Or 2, you can give them a new instrument that preserves their collateral and gives them the economic value of what they're due, right? So the debtor has some flexibility there on how to structure treatment to a secured class. For an unsecured class, it's even easier. You can cram down an unsecured class so long as no junior class to it, and junior typically being equity, is receiving anything under the plan. So as long as you can say, I'm not giving anything to equity, you junior class, I'm going to give you whatever's left over in the pie once I parse out the amounts that I need to pay pay secured claims in order to comply with the bankruptcy code. So there, you know, kind of one of the first things you do as you get into the plan process is you have the company working with its financial advisor and coming up with a business plan and coming up with an enterprise value of that new business. And once you figure out the enterprise value, you start carving up that enterprise value based on, okay, how much do I owe secured claims based on the collateral? What's left over to pay unsecureds? If I take whatever's left over to pay unsecureds and I'm not giving anything to equity, I know it's very simplistic, but that's a plan that could get confirmed here in a Chapter 11.
I see. Yeah. Liv, if you want, you could give us a little bit how it works here in Brazil for approval of the plan.
Yeah, so we have 4 classes of creditors. Classes which is labor claims, and class 4 small companies. They vote on a headcount basis. And classes 2 and 3, the secured and unsecured creditors, they vote on a combination of a head count and value of the claim basis. And in order to approve the plan, the debtor needs at least 50% of the creditors attending the meeting to have this plan approved. But it's possible for the debtor to provide in the plan subclasses of creditors for payment purposes, not for voting purposes, but for payment purposes. And there is also a provision of cram down in case of a dissenting class that rejected the plan. This dissenting class needs to approve at least 1/3, needs to have approved at least 1/3 of the creditors attending the meeting. And if it does, then the court can approve the plan. And I think it's also worth mentioning that in Brazil, we don't have those tests like we have in Chapter 11, but there are precedents recognizing that our courts can make a legality control. So the court is not entitled by law to make those types of tests to check if the plan is fair, or if there is a discrimination and unfair treatment of creditors. But the court can make this legality control of the plan and declare a determined provision as null and void if it does violate the creditor's rights. So it is possible, for example, to create the subclasses, but you need to have a rationale, and creditors need to have similar interests so that the debtor can create those subclasses.
No, that's great. And I think, I mean, somebody said an interesting question by the chat is that sometimes here in Brazil, I mean, the debtor files for a plan, and given the, I mean, time-consuming system that we have, and sometimes even opportunistic behavior by the debtor, because he knows that the procedure here in Brazil plays out for a certain amount of time, and obviously he uses this to his benefit. One of the things that we have a lot is creditors, sometimes they face a hard decision, which is approve a plan that does not have attractive economic terms, but which would be better or almost similar to a liquidation, okay? Which, I mean, is a very troublesome procedure here in Brazil. I mean, time-wise and to extract value. Okay? I know there are not a lot of legislative proposals and bills trying to reform this, but for now, this is what we have. How is this seen in the U.S.? I mean, do the creditors also use, I mean, how would they receive in a liquidation as a guideline to approve or not approve a plan? What is the rationale usually in these types of situations?
Yeah, great question, Herbert. And that is one of the things that the bankruptcy court is asked to look at. So once the debtor has formulated the plan, it has gone out and solicited votes on the plan, and let's assume that it does have one or more accepting classes, the court still has an independent obligation to evaluate whether or not to approve the plan. And there's a couple of ones that are relatively easy to satisfy. There's some that can be the subject of some debate. And one of them is the plan providing more to the creditor than if the company were to simply be liquidated, and utilize a hypothetical liquidation analysis that the debtor normally attaches to its plan and to its disclosure statement, the disclosure statement being the solicitation document that's used to solicit votes. Typically, I mean, creditors like to make that argument if they're receiving very little under the plan, but I will tell you, can easily demonstrate, look, given my situation, if I were to be liquidated, creditors are going to do and fare much worse in a liquidation than under the plan. So while there has been some litigation around, do I do better in a liquidation, with what the bankruptcy code calls the best interest test? I will tell you that typically the debtors have little issue satisfying that. I think the bigger issue, and it can work to the creditor's benefit or it can work to its detriment, really is once the enterprise value has been established and you start divvying up that enterprise value depending on who has what priority, there really isn't much argument, because you're simply giving that creditor whatever it is entitled to receive from that enterprise value once it's been carved up. So the only detriment there for the creditor is from the standpoint of pure timing. Again, we'll pick on the airlines for a second. Right now, if you think in terms of how much is an airline worth, could there possibly be a worse time for a creditor to have evaluation done on an airline? And that's what's going to happen in these cases, right? You're going to have Avianca and LATAM perform a valuation that is going to be artificially low compared to past periods. And they'll be forced to defend that valuation and say, look, we don't expect that passenger traffic is going to come back to pre-COVID levels. It may come back to 50% of pre-COVID levels. And therefore, we created a valuation based on what we anticipate passenger traffic to be in the post-COVID world. And sorry, the valuation now only generates a recovery to unsecured creditors of 10% or 15%. I'm just picking a number out of the air. But I think they'll be able to very easily establish that a 10 or 15% recovery to an unsecured creditor is better than a liquidation of those airlines, right? If you think in terms of what distributable value there could be to an unsecured creditor of one of these airlines, all the aircraft are either secured or worth very little or nothing. Their brand value in a liquidation has zero value. I'm not sure anybody's interested in buying the brand of an airline that's being liquidated. And so what's left? Very little in the way of assets that you could monetize to give us a distribution to unsecured creditors. So I don't think that the airlines are going to have a very difficult time establishing that they're giving more to creditors than what that creditor would receive in a liquidation. So it's going to be a pure timing issue in terms of what's the distributable value under the new business plan, per creditor or per creditor class based on what that reorganized airline looks like.
Yeah, and I think.
Sorry.
Go ahead. No, go ahead, Liv.
So Pedro, in Brazil, we don't have the best interest test. So in theory, the company may file a plan that is worse than a liquidation case, and creditors, if they want to, they can approve. There is no objection to that in our law. But usually, especially unsecured creditors, they do approve a plan that it's not good at all, because in a liquidation scenario, tax claims they receive with priority in comparison to the unsecured creditors. We have like a similar treatment of tax claims like in a liquidation case, so a Chapter 7 compared to a Chapter 11 case, like there's a different priority ranking considering a liquidation scenario, or it's the same?
No, it's a great question, Liv. So there is what we call a priority waterfall here in bankruptcy. It applies in not just Chapter 11 cases, it applies in liquidations under Chapter 7 and the like. And yes, tax claims do enjoy a priority over regular unsecured claims. Some labor obligations and benefit obligations to employees enjoy a priority. So I think somewhat similar to what you're used to seeing in Brazil in terms of what types of claims enjoy a priority.
Okay. And I think an important thing that a few people have mentioned so far is that what happens if you don't approve the plan? Are you bankrupt abroad?
So the debtor obviously wants to avoid a situation where they go through the entire solicitation process and don't even get one class to accept the plan. So what they will do is they will start negotiating with creditors even before they present the plan, even before they start soliciting on the plan. And they'll go out to separate creditor classes, especially large creditors, and negotiate with that creditor on a particular treatment that creditor would accept. So by the time you actually go and solicit votes on the plan, you've gotten a handful of creditors, maybe even more than a handful, already saying that they will accept the plan if they receive the treatment that the plan is going to provide them, right? Because the last thing you want is, it's a very lengthy process. It's very time consuming and very expensive. The last thing you want is to go through all of that and have a plan that fails. So you want to have as many creditors as possible on board. You know that there are going to be some creditor classes that you're never going to get them on board, and you're prepared to cram them down under the plan, using the bankruptcy laws to cram them down.
Now, I mean, we've here in Brazil, we've evolved to having our RJs with a lot of Chapter 15s. Now we've evolved to have directly the Chapter 11. I think the next phase in this game would be a Chapter 11 in conjunction with the Brazilian RJ. Okay. Now, how do you guys see that interplaying? I mean, how exactly would, given that we don't have a recognition procedure of the two judicial proceedings, they would effectively be separate. How do you guys see this type of interplay?
Liv, you wanna go first, and I'll go after you this time.
Okay. So considering that Brazil does not adopt the ancestral model law, if we do have a parallel proceeding in Brazil, we can use the provisions in our civil procedure code that the courts in Brazil may cooperate and coordinate some of the acts with a court abroad. So that's probably the two that a court would use in Brazil. And I think we have a case, a Varig case in the past, that the judges, the courts in Brazil coordinated some of the actions and some of the sale, especially the sale of assets, but it was a liquidation case. It was not a Chapter 11 reorganization, but the judges were able to do that. The courts were able to communicate and make it happen somehow. So I think that's probably what would happen in a case in the future. But I'm very interested to know what Pedro thinks about that.
There is precedent here for what we call parallel cases. The precedent's been mostly with Europe, where they are standalone, simultaneous reorganization cases in the home country in Europe, but the European companies also utilizing Chapter 11. The US courts here have, I think, been very good in coordinating with the foreign court, or I guess in this case, they are the foreign court, coordinating with the home court on how to best establish protocols on utilizing Chapter 11 for issues that are more US based and maybe utilizing the home country's insolvency laws for dealing with other issues. So I think back to where we were a few minutes ago, I think I could see a scenario where a Brazilian company could utilize Chapter 11, utilize RJ at the same time, and maybe say, have the US judge and the Brazilian judge agree, okay, obviously labor issues are under Brazilian law. The Brazilian proceeding is going to take the lead on how we deal with the labor issues, but how you restructure the New York law governed debt, we'll let the Chapter 11 case take the lead on how we restructure that debt. I could see that kind of protocol and that kind of coordination happen between the two courts.
Yeah, I mean, we would need to have to use a lot of common sense, given the lack of precedent we would have, especially here in Brazil, I think. I think fielding another question that we received through the chat, one of them is very interesting because it happens a lot here in Brazil, is regarding if a creditor disputes with the debtor exactly his claim is classified. So say, for example, that the debtor questioned the collateral that was given, put him in an unsecured class, and this creditor is then, I mean, obviously he's disputing this claim. How does this procedure work? And I think the more practical matter, if I approve the plan with the debtor's classification or whatever timing that is, and then this is decided afterwards, does it revert or not revert the plan? I think that would be the more practical case.
So let's deal with the first question, which is, I disagree with the debtor's classification of my claim. Even before the plan is filed, normally the debtor will establish a period for creditors to submit their claims for verification to try and avoid this very issue. It's typically, the deadline here is they call the bar date for presenting your claim. A creditor's claim, if timely filed, is deemed to be valid unless someone objects to that claim. So here I am, I believe I'm a secured creditor. I file my proof of claim timely, saying that I'm secured by this collateral, and the debtor disagrees with that. They say, I never gave you a lien on that collateral. The debtor is going to be required to object to that claim. They can't just separately classify the claim as an unsecured claim because they disagree, and they'll need some type of order from the judge agreeing with them, at least preliminarily, on how to classify that claim before they can just decide unilaterally to call it an unsecured claim. So if I'm a debtor and I disagree with the creditor who's saying I have a lien on all of your equipment, for instance, the debtor will file an objection to that claim, and they'll file a motion with the court to treat the claim in a particular way for purposes of the plan. That happens not all the time, but it happens often when you have this disparity between what the creditor and what the debtor think of that claim. So the creditor in this case will have a chance to respond to the debtor's objection to that claim. It's not as if the debtor can just simply wave its magic wand and have the claim treated as unsecured, there'll be a process by which the court will have to decide on how to treat the claim for purposes of the plan.
Yeah. I mean, Lib, if you want, you can give a little background on how this claim contest happens here in Brazil, given it's a frequent issue we have also here.
Yes, so the debtor files a list of creditors, and the creditors are able to challenge this list. And this first analysis will be made by the judicial administrator. He will check the documents. So, and here in Brazil, the classification of a secure claim depends on the value of the assets. So that's probably what the judicial administrator will check. After that, the judicial administrator will release a new list of creditors based on the documents sent by the creditors. After that, creditors will have a new chance to challenge the list of creditors. And this time, the court will analyze the documents and decide on the claim. But this proceeding, it's an ancillary proceeding to the court, and it might take time. So sometimes we have a creditors meeting, and we have challengings from the debtor and the creditor on how the creditor should vote. It should vote as a secure or unsecured creditor, or part of the claim as secure, part of the claim is unsecured. So we have disputes on that, and usually creditors, they do request an injunction to the court in order to vote in accordance with what they think it should be, the claim should be classified. And sometimes we have approval of the plan, and we still have pending ancillary proof of claims proceeding, still discussing the value of the claim. But our law provides that it should not somehow affect the result of the creditors meeting. So if the creditors meeting approve the plan considering an X value of a claim, then it's approved, and the other creditors and the creditor itself cannot challenge the result of the approval of the plan based on the classification of that claim. So that's basically what happens here in Brazil.
Yeah. So I think, I mean, we're getting close to our time cutoff. We're reaching an hour, and what I think is worthwhile is to, I think, especially for Brazilian companies who are looking to study if it's worth Chapter 11, is if you could have a few words on why it would be better to file directly for a Chapter 11 instead of a Chapter 15, for example, which is what has been done in the past. I mean, why have we evolved to Brazilian companies going directly to a Chapter 11 and sort of skipping the 15? I think that would be a little worthwhile.
Okay. Can I try that one?
Absolutely, go for it.
So one very good reason why you want to do that is because you need a dip. You need a real dip. You need a sizable dip. You need a dip done fast. Come to New York or go to Delaware, or go to Houston. The second reason is, of course, it's very possible that you'll find a broader scope of protection and a broader ability to deal with whatever your liabilities are than you might find in Brazil. So someone asked at the beginning of this, can you deal with any liability in the United States? You know, frequently we see people here dealing with tort liabilities, right? Liabilities on regards of, all these churches that have gone bankrupt, the Harvey Weinstein estate, asbestos claims, mass tort, environmental tort. All these things dealt with quite efficiently here, maybe better than anywhere else. The big question, of course, that this raises, as was kind of already answered at the beginning of this, is what does this do for you in your home country? What is the likelihood of this getting recognized? Probably your chances on employment liabilities are less than your chances on debt for borrowed money. But the dip is the key reason why I would first come here rather than try this in Brazil.
Yeah, I think we covered, without saying it in so many words, I think we covered a lot of the other reasons. I think in terms of the benefit of the automatic stay, if you think in terms of the flexibility that the company has in how it divides and classifies different claims, If you think of it in terms of the standards for approval of a plan and the potential to cram down other classes, I agree with what Andrés said, and I think there's a number of other features that are available. If you want to try, for instance, sell assets and be able to monetize the value of those assets in a way where you maximize that value, we didn't get into a lot of detail during the presentation, but there are provisions in the U.S. Bankruptcy Code that allow you to do that. There could be a number of other reasons dealing with contracts that you want to get rid of and reject those contracts and leave that contract counterparty with a simple unsecured claim for the damages associated with the rejection of that contract. So there could be a number of different reasons why Chapter 11 makes sense. And I think you need to evaluate all of those advantages with potential disadvantages, like how do I deal with other obligations where I may not be able to, because of legal or practical reasons, to restructure through Chapter 11, and how do I deal with that? And I think Liv came up with a great suggestion or idea in terms of you may need still a home country proceeding to deal with certain obligations, and maybe you have them done in parallel with a U.S. Chapter 11.
Yeah. No, I mean, it makes perfect sense, of course. I think to conclude, I mean, if anybody wants to say some last thoughts, I mean, give a little bit more color on any other subject. I mean, this has been a pleasure for me, very enlightening. Anybody want to say a last few words?
I'll give the last word to Andrés, who's been monitoring the LATAM dip very, very carefully. I think what happens there will give us a lot more insight into how these Chapter 11 cases for foreign companies will go moving forward.
I think we're all waiting really with a great deal of interest to see how this dip dispute comes up. The structure that LATAM is trying had been sort of threatened before, but I don't think we had seen it play out ever. And if this ends up working, it's going to create a very interesting dynamic for Latin American companies, where there tends to be a controlling or a majority shareholder, a plurality shareholder who may have a big interest in deciding when to, for example, put fresh capital into the debtor. Does he or she want to do this before filing because he wants to prevent filing? Or does he or she want to do this as a process of a bankruptcy because he might have a better upside on the other side of the bankruptcy, and at the same time, he might get rid of a ton of undesired liabilities, problems in various ways. So I think that we're all sort of very interested in seeing what happens over the next week or two on this LATAM thing.
So I guess, Herbert, the last word is stay tuned. We'll have to see
Yeah.
what happens.
No, I guarantee we'll be on the news, no problem.
Yes.
Okay, guys. I mean, I want to thank you guys once more on behalf of IBRADEMP. I want to thank our audience for having tuned in. I think it was a very enriching and an absolute pleasure for everybody. And my sincere thank you.
Thank you.
Thank you very much.
Thank you.
Yeah, thank you, guys. Have a good one.